And of course, welcome everybody. I'm getting an error message that says that the host has another meeting in progress, but I think I might be that other meeting. So I'm going to go ahead and move forward unless somebody cuts me off, but that's kind of where we are at the moment. Anyway, thank you all for being here today. We are at the Greater San Diego Association of Realtors. And let me double check my mic and make sure that I've got sound. Here we go. Okay, I did not in case. Anyway, okay, thank you all again. Let me go ahead and get us back over to the screen that you're on, which is very helpful always. My name is Kevin Burke, and there is my telephone number, and there is my email address. If there's anything that I can do for you, I am happy to help in any way that I can. I do have some credentials that allow me to speak about the subject matter today, most importantly, risk management. So I was chair of risk management for the California Association of Realtors. I was last year, I was risk management for the National Association of Realtors West Group last year. And interestingly enough, next year I will be the chair of the Legal Affairs Forum. So certainly a couple of really nice titles to have. But as you can see from my focus, I'm all about the legal aspects of real estate, even though I am not a practicing attorney. I do teach attorneys, as you can see over here on the left-hand side, and has another meeting in progress. I don't know why. Linda, raise your hand if you could. Do you see me okay? I'm trying to make sure. Oh, I got a couple people. Okay. Hi, Hannah. All right, looks like I got a couple of people in here. Good. Okay. We are probably going to be talking about stuff that's going to appear to be legal. I am not a practicing attorney. I'm very proud of that. In fact, 2 minutes, maybe a minute and a half before we started, I had an attorney call me. So it's like, and I just knew I was going to catch a bunch of crap. So I took the call really quick and I said, hey, you know what? I really can't talk to you right now. I got to start a webinar. So anyway, I do get a lot of calls from attorneys and usually somebody's in trouble for something. So we'll talk a little bit about that today, because I've got some really good solutions for you to keep you out of harm's way and to hopefully make it so that you don't have any kind of issues. So I do a lot of trial work, mostly limited to testifying as an expert witness. Standard of care is my specialty. Agent duty of inspection and disclosure and market conditions in San Diego County. Those are my things. In fact, the question I got just a minute ago was, do you do trial work in Florida? And the answer is, well, yeah, all over the country, right? Because I do standard of care, and standard of care is code of ethics and things like that. So we'll talk about that today. So conversation today is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Okay, our webinars are intended to be interactive, so please, you'll do me a big favor if you chime in and just say something every now and again, ask me a question. I am happy to help. Please utilize the Q&A button to ask questions or offer input, and I do very much look forward to hearing from you. So good. Today is August the 3rd. We're going to talk about the top 10 risk avoidance techniques that I have found in my experience to be very effective. And then this afternoon, we don't have anything on the schedule because I will be doing a private talk for a very large brokerage in San Diego. And that will be certainly available to you as well if you want me to speak at your brokerage office. We do arrange those talks on a fairly regular basis, mostly by Zoom or Google Meet or Microsoft Teams, those kinds of things. So again, today we'll talk about top 10 risk avoidance techniques. And so on Tuesday, we'll talk about the top 6 disclosures. We've got some doozies that I do see missing from files, and it just amazes me. I mean, I've got a transaction right now where the broker's refusing to give us one of those top 6 disclosures. And so we're on record for having asked them repeatedly for it, and they have repeatedly denied. And so we'll have that in our file to be able to prove later on that we tried to get it. So that's all. And again, risk management, right? So, and then on Tuesday afternoon, we'll talk about residential property management forms. And then so we're going to be off to the races here. So member benefits, thank you for joining us. The top 10 risk avoidance techniques. Okay. All right. So who are we afraid of? And I put this together because all I could think about was, oh my gosh, everybody, the calls that I get, there's usually two people that are two people threatening. And one of them, of course, is the lawyers, right? So when the lawyers are calling, and especially if you get a call from a lawyer, you need to kick that up to your broker right away. Chances, unless they're a client, of course, mine are all my clients are lawyers, but almost all. But anyway, if you get a call from an attorney, or certainly if you get a letter from an attorney, you want to make sure that you kick that up to your broker, because it's really important. Your broker is there to represent you. Your broker is there to defend you. And so we want to make sure that the broker's aware of the fact that you're getting a letter. The worst thing that you can do, folks, is ignore it. You do not want to ignore it. Okay. They tend to get paid for being tenacious. Okay. They tend not to go away. All right. So, which is kind of funny, because I was just throwing out a bunch of stuff, from back, in about 10, 20 years ago, letters I was getting from attorneys who, I told them I'm not going to represent you. And so I ended up throwing a lot of stuff away. Letter would have gotten a kick. But anyway, so who are we afraid of? We're afraid of the lawyers, and why? Because, it can cost us a lot of money. We're afraid of the California Department of Real Estate. And those are the two biggies, right? I mean, I think of all the things that we're afraid of. And so, and I say again, why? Because lawyers cost us money? Well, yeah, they do. And the DRE has said that they can make more money off of enforcement than licensing. And so I'll never forget, that was in a meeting with Wayne Bell, who I had a tremendous amount of respect for. He was an attorney. He was the commissioner of real estate. He was the head of the enforcement division for the Department of Real Estate for over 20 years that I knew of him there. And so he was quite an interesting guy, but he said, we just kind of figured it out that, the dues formula, because we put a cap on how much they could charge us. Once they get, up to $30 million in reserves, we had created a legislation called the poison pill provision. And that poison pill provision said that they had to cut our dues at that point, because that's all the state would, the governor would reach in and take the money, the surplus out of the account. The Department of Real Estate is really the only money making entity at the state of California. So interestingly enough, we created a poison pill provision, which prevented them from going over 30 million. And once they did that, they had to adjust our dues accordingly. So I probably, a lot of people know that, but a lot of agents, again, if you've had a license for less than 5 years, the chances are pretty good that you don't know that. And that's just because that legislation was 15 years ago. And so interestingly enough, the Department of Real Estate changed their name to the Bureau of Real Estate just to avoid the legislation. And so for, I don't know, they were for 8 or 9 years, they were the Bureau of Real Estate. And then ultimately they just went back to the Department of Real Estate, because they were under the Department of Financial Oversight when they were the Bureau, and they really needed to be a freestanding entity. So again, a lot of trivial knowledge here, and some of you will appreciate what I'm saying, but it's not critical to your career. So if we're afraid of these people, what are some of the solutions? And so, I want to take a look. All right. So let's take a look at a couple of things in here, and I do have a lot to share with you. So a lot of information here that I'm going to pull up one at a time. This one is an article written actually by Wayne Bell. But let's go back here. So the first thing that I want to talk about is staying within your boundaries. And I've had other people say stay within your lane. I've had different interpretations of this, but I'm going to tell you something. The easy solution to it is, your standard of care. What you are held to is that education required to get your real estate license. And where we get in trouble is we start doing things and saying things that are outside of that. I had a lawsuit not that long ago now, where the entire lawsuit, millions of dollars in legal fees, all stemmed around. It was a harborfront property up in Laguna or Mount, I think it was Balboa, a harborfront property, and the agent, the buyer's agent, was with the buyer at the property. And remember, again, it's the buyer who sues normally. So the buyer's agent is with the buyer at the property, and they're out on the slip, out in front of where the docking place for the boat, and it was low tide, and the buyer was wanting to be cool, and the buyer's agent wanted to be cool, and the buyer asked them a question. They said, "How does the stem wall look?" And so, because it was low tide, the agent, who really wasn't sure what a stem wall was, okay, now, does anybody remember a real estate question on the state exam regarding a stem wall? And the answer is no, it's not there. I teach the real estate exam, so it's not there. But the agent, who thought he could see the stem wall, again, he didn't know really what it was, but when he looked down there, everything looked to be okay for him. And so he said, "The stem wall looks fine to me." And that was it. So, I don't want you to be afraid of saying things, but I would tell you that if somebody asks you a question, usually the buyer, if the buyer asks you a question about something, then the answer is always this. And I probably should put this on my PowerPoint, but that's a really good question. Okay, let me find out and I'll get back to you. And so that's my standard answer. And I'm not looking for the answer. I am going to look for the source of the answer. And we're going to talk about that in a minute. But I'm always going to say, that's a really good question, because I want to start off with a compliment, right? Let me find out, okay? And then what I'm really doing is I'm going to go find out where the source is, right? Okay, because it's the buyer's duty to investigate, not the agent. The agent's obligation is only to inspect, right? And so and let me get back to you. And so, and then get back to them. Don't tell them you're going to get back to them and then don't get back to them. That's pretty simple, right? So, we all have resources. People ask me, I remember I was showing a property in Del Mar, my hometown, and all the houses on the street were all two-story houses, except for one house. And that one house, of course, was the only one on the street that was for sale. And the buyer said to me, he said, "Can I build a two-story house?" And I'm looking up and down the street. Now, most real estate agents would have probably said, "Well, of course, all the other houses are 2 stories." Unfortunately, I got a little bit of background on the subject, and so on the legal side of things. And so my response to the buyer was, here, 858-755-9313. And they said, "What's that?" And I said, "That's the telephone number to the city of Del Mar Planning and Zoning Department." Okay. And so they said, "Oh, how do you know that number?" And I said, "Well, I call it on a regular basis, and I find them to be a very good resource for information about how much, where and how you can build on a property." So a lot of people don't know that the difference in the area, if the Del Mar zip code runs from the ocean to the I-5, and in some cases east of 5, but they're 2 completely different cities, right? So you get halfway up the hill and you hit Crest Canyon, and most everything west of Crest Canyon is city of Del Mar, and most everything east of the canyon is city of San Diego. So different law enforcement, different post offices, very different situations. And by the way, the floor area ratio is very different as well. And that means in the Del Mar area, Del Mar part of the 92014 zip code, you can only build 25% of the lot. So if the lot is 10,000 feet, and good luck finding one of those, and then you can build a 2,500 square foot house, versus the city of San Diego side of Del Mar, and there it's a 65% floor area ratio, which means that if you've got a 10,000 square foot lot, then you can build a 6,500 square foot home. So we certainly don't want to tell the buyer, whether we know or not, because certainly in Del Mar, it can change on you depending on the whim of city council. And I've got personal experience with that as well. So again, if you don't know anything about stem walls,
then don't answer the question about stem walls. That's a great question. Let me find out and I will get back to you. Okay. If you don't know, as a matter of fact, and it wasn't included in your real estate, both of my examples, by the way, are not on the state exam. Okay, so the stem wall is not on the state exam, and whether or not you can build a 2-story house in Del Mar is not on the state exam, and they're nowhere in any of the educational materials. And as Linda will tell you, I've taught almost every single class that you at the college level that you would need to get your real estate license, and all of those classes were DRE approved classes. And so I'm going to tell you, by the way, the buyer in the first situation that filed the lawsuit happened to be an attorney, happened to be a real estate attorney. Okay, and so and then in addition to that, they were a real estate broker, and so they knew the answer that the agent should not have given them. The real issue was that they thought they'd overpaid for the property. Well, there's a surprise, because they were also a certified appraiser. So lots of interesting things in that situation. But at the end of the day, the agent would have protected themselves by not opining on what the condition of the property was. It'd be a contractor's position to say something about it, or a physical inspector's position to say something about it. But I ended up, and it went on for such a long time, and I was the closing expert. And I've seen enough videos now of what those eels look like that eat away at the concrete underneath the water that, I didn't ever do anything about that. And so the buyer's agent didn't know anything about it either. So don't offer opinions on something that you don't 100% know the answer to. And again, why risk it? Why not refer them to the source? So again, Wayne Bell, who is really a super guy, I liked him a lot. He wrote an article. He's probably at the time, and I haven't had a chance to read much of Macaulay's stuff, but at the time, I think he was one of the best writers we ever had. And I've always been really close to the commissioners, Jim Ant and Levy and Paul, not so much Paul Reddish Zinnemann, but Pat Neal. And so, it's all because of very interesting. I listen to what they have to say. I'm not afraid, and I don't think you should be either. But that's why we're doing this today, is to let you know that this is just a part about being professional. And so here's the professional movement, which is an article written by Commissioner Bell, and I haven't highlighted it, and I probably should have, but in fact, let's do it right now. But anyway, so if you go through this, and again, as always, I will send all this to you. So but let's see, I can find this pretty quickly. The rules change, as you know, the education changes, as you know, and let's see. Of course, I promised you that I would find it fairly quickly, but and it's not popping out to me right away, other than raising professionalism in our industry. And I know it's in here because I quoted them. Okay, let me see here. I've posed queries, response I've gotten, et cetera, et cetera. Anyway, I will send this to you. There's no sense in me spending a whole lot of time on it, but the article did appear in the newsletter from the commissioner, and so if you haven't already, I would recommend to you that you go to look at this. Be civil, be kind. And this is coming from the commissioner of real estate. So I find a lot of my stuff involves people that are just plain jerks. So and again, I'm trying not to let this go. I'm still continuing to read this pretty quickly, but again, I've read it before. All right, I'm going to have to stop, but I do want to show you a link, and that is, here we go. Here's his conclusion. I finally found it. Look at that. So let's highlight it now so I don't have to do this. Oh, it's not going to let me do it. Darn it all. So it won't let me highlight it. How about if I don't have the access code to it. Okay. All right. So anyway, here it is right here, and it's on page 4 or 5 at the top. So my conclusion is that professionalism in performing real estate license services requires licensees to have the knowledge, skills, and abilities gained through education and or practice and experience, and thoroughness and preparation, including organization and diligence, to well and ethically represent their clients. So again, education, training, practice, experience, and mentoring make perfect. So I think a very good article. Let me show you, I do want to show you something that you really do need to have incorporated in your program. So I'm going to go to the Department of Real Estate's website. So dre.ca.gov. I go there a lot. When I scroll down to the middle of the page right here, you see that orange link right there? It says RSS. That stands for Really Simple Syndication. I'm going to recommend to you, if you want to stay on top of things, that you click that button, and then as you see, I would put your email address in both of these fields. It doesn't highlight you as a problem child or anything like that, but what it does do is it does send you updates. And so whenever the commissioner updates their regulations, or whenever they come out with a bulletin or things like that, this is a great place for you to have your email address in there. And again, it doesn't put you on a list. You're already on the list, right? You're already on the commissioner's list, but put your name in each of these, and it's right on the homepage. Okay. And so I'm going to tell you, probably one of the most valuable lessons I give to people is that you need to be aware of what it is that the department is looking at. And so whenever you get that bulletin, and the bulletins come out, so if I go up here to publications, and I go to the real estate bulletin, see it right here, real estate bulletin. I'm going to pull that up. I'm going to pull up the spring edition. And again, I know you can see this because it's opening up in my browser, but hopefully, can you see that? I think you can. Yeah, you can. Okay, good. And there's Commissioner McCullough. So here is his stuff. So changes to pre-licensing requirements. I'm going to fly through this, just really fixing it. The new real estate law book is available. I think you get it for free. I think it'll download it for free. Yeah, there you go. Download for free. If you want a copy, a hard copy, I'm sure they would sell you one. But here's California real estate law. And so, it's an interesting little quiz. And if you don't get, 100, then you need to brush up a little bit, because these are big things. Okay. Living in a common interest development. Some of the articles have been just knock it out. Really, really good. Helping your client understand the architect's role. I mean, it's a whole separate licensing. So you certainly don't want to make any opinions as to whether or not a property is structurally sound. I have a lawsuit on that now, where the agent opined that the property was structurally sound. So anyway, broker supervision requirements under California real estate law. Again, regulation 2725 and B&P code down here 10159 and 10177. Is if you've looked at the realtor acknowledgement form, you'll recall that 10177H is the code that is quoted about people that call themselves realtors and are not realtors. So this is the most current article. And again, lots of really good information in here. Again, big deal for them right now is broker supervision. And then we also have updated rules for discrimination as a basis for discipline. As I always say, they've got to tell you, otherwise, they can't really fine you for it. So in this case, certainly an excellent article to read. And then, of course, they give the commissioners inside scoop on the complaint process and what that looks like. And kind of the summary of that is that anybody can file a complaint. They encourage people to do it. And it's a very simple matter. It's on the homepage of their website. I know that just recently they came out with an article that I received an email from the Secret Service regarding land scams. And so I know that they're making a big deal about those land scams right now. So the FBI certainly talks about it on a regular basis. And here the DRE is on Mastodon and Instagram. I mean, they're just really, they're getting into the 90s, as we say. I didn't know they were on Instagram. Linda, we're gonna have to go ahead and sign up for that, right? Anyway, all those cool things and et cetera, et cetera. So again, wanted to just share that with you so that you would know about it. Here are the answers to the questions up on the top. And then, of course, information about your stormwater. So why is it important to know these things? Because the Department of Real Estate is telling you that these are the things that they are encountering right now. And so that means these are the things that they're also investigating right now. Okay. All right. Okay. That being said, back to the go back to my homepage really quick. And so verifying how to file a complaint. Here it is. And so they're making it really easy for the public to file complaints against real estate agents. As I have told you in the past, they have an obligation at law to respond to all complaints. So it's just one of those things. You do a transaction with somebody and they're not happy with you, and so they'll investigate it, and then they'll probably, based on the merits of the case, it'll be their decision whether to follow through with the complaint or not. Okay, everybody good with that? All right, so let's go back. So I just wanted to repeat back again, stay within your boundaries, or as I've had people say, stay within your lane. It's interesting. I had a meeting with the district manager of the Department of Real Estate, and she made a comment. She said, you're in San Diego. If you're doing transactions in Temecula, you're probably outside of your field of expertise. And I thought that was kind of interesting. And of course, in my opinion, my humble opinion, I have a real estate license in the state of California, but I have to agree with her. I mean, if you're doing transactions in Temecula, do you know what the disclosure laws are in Temecula? Do you know what the rules and regulations are in that area, so that you can warn your client of what to be careful about? Okay. Anybody have any questions about any of that? And we do transactions all over the state. We have a broker in our office who lives in San Francisco, who happens to be an attorney. And so, we're not afraid of it. We just research the heck out of it. Right. Okay. All right. That being said, let me move my screen a little bit. So again, do not make representations outside of your field of expertise. So if you don't, any kind of representation that you make, be prepared to defend it. So try not, Linda says, I'm a very different person when I'm in front of a client than I am when I'm, teaching a class. Because when I'm teaching a class, obviously I've got things going on. I'm telling you things, stuff like that. It's a lecture. When I am with a client, I ask a lot of questions. And there's a lot of blank space, so when I'm with the client, I ask questions, find out what is important to them, and then I act on it. So if you don't ask questions, how can you represent your client? I mean, that's just kind of the way it is. All right. That being said, remember number two, we're at number two now, half an hour into it. Remember to whom you owe your fiduciary duty. And so people ask me all the time, what is a fiduciary duty? Well, it's a fiduciary duty. So we're going to use the term to define itself, something I really don't care for, but okay. A fiduciary duty of utmost care, integrity, honesty, and loyalty in the dealings with either the seller or the buyer. Okay, so, and again, remember, you have that agency disclosure form that I did not pull up here, and I probably should have, but that agency disclosure form, the current version of it does a really good job in explaining that even if you're representing the seller, you still have a duty to the buyer. And even though you're representing the buyer, you still have a duty to the seller. So, regardless. And then, of course, when you're a dual agent, you have double the pleasure, double the fun, double the risk. So, a lot of people will talk about pocket listings and stuff like that, but it's fun to get paid twice as much, but at the same time, your liability goes way up. And I'm going to tell you, not double, but triple. So, but we'll talk a little bit about that. So on the seller side, what does that look like? Well, pocket listings. And so again, I'm looking at fair housing issues. Okay. And so, so we actually do have in the, let me go here. So we do actually have, and I'm going to go ahead and close this part of Wayne's presentation down, fair housing laws, believe it or not. And so in those fair housing laws, we discuss things like discriminatory effect versus discriminatory intent. And so in some cases, you didn't intend to do something or say something that was discriminatory, but it had the effect of it. Like the agent that we had in our office that used to be with us, sent me a flyer to review before she sent it out, and it said on the flyer, get out of the neighborhood while you still can. And I use it as a really good example of a fair housing potential discriminatory effect. And so we stopped it before it went out, asked about what it was about. And her response was that they were building a water treatment plant in the community next to the property, and so okay, well, the way you wrote it, it didn't sound so good, so we need to rewrite that. Okay, and we did, and so only because we have to be careful. We have in California we have 22 protected classes, and the biggie at the end is any arbitrary characteristic, and so just be aware that there's people get offended by things, and so but these are all protected classes, which means they're fair housing violations if you discriminate against any of these people. And by the way, these are the California protected classes. And then there's the federal protected classes. And so you're in California, you're subject to both. So the Fed doesn't have as many. But either way, I would probably review this and understand, that you're going to have in your continuing education, you're going to have additional coursework now. They kept the number of hours the same for your continuing ed, but you will have classes, increased classes on fair housing and on discrimination. And so what are the best practices to avoid violating fair housing laws? I think education is the most important thing. And again, I'm preaching to the choir here, but selections of neighborhoods, we call that steering, right? Licensees should provide a complete and objective information. And this form, by the way, came out of a very interesting Newsweek hidden camera up in northeast coast of the country, Rhode Island, where they went around to real estate offices and interviewed with people, and it's amazing what we were seeing, the responses by the real estate agents. You won't like that neighborhood, it won't be good for you, nobody wants to live there, things like that. I don't know. I mean, I watched that, and a lot of it in there was really ugly. Okay, so again, steering, and then real estate licensees should provide the same professional courtesy, and you get this in all of my webinars. Everybody fills out the same form, everybody gets the same respect. Housing providers, we've changed the name from property owner, or from the agent or the property manager, to housing providers. Should not make any statement or advertisement that directly or indirectly implies any of those things. And then again, housing providers make the process the same for everybody. Reasonable accommodation requests, et cetera, et cetera. Be aware of possible unconscious bias, and that's what the subject is of the DRE information. So again, I'll send all this to you if you want it, but this is just a quick guide. And then we'll talk about non-contingent offers in just a minute. I've actually queued my stuff up. It's in order. That little asterisk down there means that's something I'm going to want to talk about. So when you have a pocket listing, how could that be a fair housing violation? And the answer is this, and the Department of Real Estate has said this. They have said that you picked the neighborhood. So you picked the person who was going to live in that neighborhood, and they think that's potential is steering. Okay, that's their position on it. And I've always said, did you give the world an opportunity to bid on that property, or did you instead pick the person that was going to live in it? And we have some very interesting lawsuits on that. And so again, I don't like pocket listings. I've been against them since the beginning of my career back in the 70s. Do people still do it? Sure. Why? Because I get paid twice as much, and I'll just kind of suck it up if I get sued. That's just not a very good, I mean, certainly tell your broker you're willing to do that, and you see how long you last at the brokerage. But again, and by the way, that meeting where the Department of Real Estate said that, the FBI was in on that same meeting. And so for a while, they were watching the listings as they could see them on the screen. On what they could see was the listings that sold immediately. We used to put in, sold before processing, which was really just another way of saying I found the buyer myself. And so we have some solutions. I'm actually going to be doing a talk on this afternoon regarding clear cooperation. And so anyway, coming soon listings and what we do with coming soon listings and things like that. So dual agency, I think we have some real issues when we are the dual agent. Again, the pocket listing kind of lends itself to dual agency. And remember, dual agency is not necessarily that you represented both the buyer and the seller, but that you represented one and someone else from your brokerage under the same broker represented the other. Okay, so I I had a lawsuit in San Francisco where the agent took a listing on a property, took it for $2 million, goes back to the office, and this was 15 years ago. Couldn't buy that property today for under 8. But anyway, so they go back to the office, and of course, oh, gee, look at that. Somebody in their office had a buyer for it. And so before they put it in the MLS, they put the contract together. Well, of course, the property was owned by owned in trust, and there was an attorney for the trust. And the attorney said, well, did you put it in the MLS? And they said no. And they said, well, I want you to put it in the MLS. And so the agent did. They put it in the multiple listing service. They got a full price offer for $4 million, twice the asking price, all cash. And needless to say, enter the lawyers. So, because obviously they were just trying to get away with doing a good deal. Now, are all of them like that? Well, not necessarily, but that's a pretty good indicator. Okay. All right. Okay. So that's on the seller side of things, and those are just some examples. On the buyer side of things, what about when I write multiple offers on multiple properties? I mean, it creates an interesting paradigm, right? So the buyers threatened in this economy because they can't get an offer accepted or whatever. So then they tell you to write 5 offers on properties, and let's just see which one sticks. Well, again, you have a lot of issues with that. Of course, among those issues is the buyer able to buy all 5 properties? And remember, buyers are going to suggest to you certain things, and sellers are going to suggest to you certain things that aren't, that maybe aren't legal. In this case, that's not a legal issue. It's just an issue of whether or not they get committed to more than one offer, more than one property, and then what? Now you're gonna, well, I can get you out of the deal for any reason for 17 days. Now that's called interference with contract. That's a tort. So that's against the law too, right? So, I'm telling you this, and again, I'm preaching to the choir. Those of you that are here today want to know, but when you're writing offers on multiple properties, you're running the risk that the buyer's offer does get accepted. I think most agents today just assume there's going to be a counter offer, and they have a pretty good idea that the counter offer is the death knell of the original offer. But that's not something I would put ground on. Did you notify the seller's agent that you're writing offers on multiple properties? And when I talk to people about this, and they come back to me and they go, no, we didn't tell them. I go, why not? And they said, well, because they won't accept my offer. And it's like, well, then there might be a reason for that. But if you're going to write offers on multiple properties, there's some other solutions for it. And again, I do get a lot of phone calls from people that say, they start off the conversation with, I know the law says, and I stop, I'm not going to help you break the law. And so, but that's what they're looking for. They're looking for some way around it. So if I was writing multiple offers for one buyer on multiple properties, I would probably shorten the time period for acceptance by the seller, right? Because remember, when I write an offer, so it's 10:38 in the morning right now in beautiful San Diego, California. When I write an offer for a buyer, I'm probably going to give the seller until 3 o'clock to respond. And so remember, when I shorten that time period, time for acceptance, I'm saying to the seller that if you accept the offer as written within the time period we've given you, then you have a contract with the buyer. Now, again, I've written one offer for this buyer. I've given them until 3 o'clock. Okay. That gives the agent time to, grandstand and do whatever, and get a hold of the seller. And so the seller has until 3. Remember, if the seller accepts the offer as written, there is a contract between the buyer and the seller. If the seller counters the offer, the time period doesn't matter anymore because the deal is dead. As you know from my other classes, a counter offer is a rejection of the offer. So as a result, the deal's dead. Okay, and some people are counting on that, but again, we're getting into the legal weeds here, and you want to be really careful about what you tell people. So what happens if the seller counters the offer and then the buyer accepts it? Well, then that's when, and the seller gives the buyer a period of time to create a contract with the seller. In that case, the seller becomes the offeror, as we say in real estate. Okay. All right. So 3 o'clock comes and goes. I don't have a response. There is no longer the ability of the seller to create a contract with the buyer. I now send out offer number 2 on another property. Okay. And so that would be my strategy. So again, there is no contract. The real estate agent on the other side, I do not have an obligation to train them. Although if they ask the question, I'll tell them, yeah, I'm giving you until 3 o'clock. The buyer is giving you until 3 o'clock to create a contract between the buyer and the seller. And if you miss the time period, then there's no contract and no ability to do that unless the buyer accepts, the seller's late signature, or if there's a counter offer or whatever. So does everybody understand? We can go back and forth, excuse me, back and forth on this for quite some time. But again, I don't want you being cute. I call this cute realtoring or creative realtoring. And so again, but in the old days, when we the old days, I hate to say that, but when we wrote an offer on a property, there was none of this 3 days. I don't know what 3 days is about. Seems like the longer time I give the seller an opportunity to accept the buyer's offer, it seems to me that I get more counter offers, right? I get more multiple offer situations on that. And we're going all of our transactions are all multiple offers. I mean, I get it. You've got to learn that strategy. But again, at the same time, it's probably about pricing, and that's what the seller cares about. So again, does everybody understand what I'm saying about writing offers on multiple properties? You want to be really, really careful. Hi, Dally. You want to be really, really careful that you understand the logistics of negotiation. That's a very important thing, right? Linda, and some other people on this call today are certified negotiation experts. I think that's a good designation to get. And again, STAR provides that. So what about my contingent free offers? I have a real hard time with that. So your buyer says, well, I can't get an offer accepted. I'm willing to write an offer contingent free, or worse yet, the seller's agent says that the seller is only accepting non-contingent offers. Well, that is going to really create a problem for the buyer. And here's the lawsuits that I'm seeing now. And again, I know we're talking a lot about lawsuits. Hopefully that's not intimidating for anybody, but a lot of the lawsuits I'm seeing are from the buyers that bought property without inspections. Now, whether or not the buyer removes their physical inspection contingency, they still have a right to investigate the property within the time period that they've got per the contract. Okay, so and I know I represented a Navy SEAL last year who was buying a property. So obviously a VA transaction, and the seller's agent said, the seller's only accepting non-contingent offers. I always love it, by the way, when the agent never talks to me on the phone, but they send me emails. And so whenever I get those emails, those become essentially Exhibit A against them at trial, right? So so just be aware of that. We're going to talk about emails in just a minute, but that contingent free offer, so the buyer agreed to it. Here's what I had the buyer do. I had the buyer sign off on the contingent free offer advisory, okay, which is a CAR form. All right, so here's the quick guide to it. So I had them sign off about this. Should you do that? Can you do that? And the answer is yeah. But why would you want the buyer not to have a physical inspection contingency, for example? And remember that the buyer is also, when they remove the inspection contingency in today's contract, they're also removing the fire insurance, the hazard insurance contingency. And if they can't get insurance, or the insurance bill is prohibitively high, they may not be able to get their loan. Okay, so there's a lot of legal issues with writing a non-contingent offer. And so and by the way, there's no such thing as a non-contingent offer, and part of that is because we have statutory rights. The transfer disclosure statement, you see that on your screen, the natural hazard disclosure statement, the Mello-Roos disclosure. We have a lot of statutory disclosures. Statutory means that the law requires them. You can't waive a statutory right. Okay, so again, and remember, one of the rights of the buyer is to investigate the property. So in that situation with the Navy SEAL, where the Navy SEAL, my client, removed the contingencies at the time of the offer, after we had our offer. Oh, by the way, the seller's agent had the seller accept an all cash offer, and that buyer never showed up with the money. So interesting situation, right? So there was somebody writing an offer. I don't know, if I was a seller, I'd probably go after the buyer on that one, but okay. So then I get the phone call that says, hey, you've done everything you said you were going to do. We're going to go ahead and we're going to move on to you and accept your offer. And of course, I made them produce a cancellation of contract with the other buyer, that kind of thing, so that I knew that we weren't going to be two escrows going at the same time. And then And then my buyer, I called the seller's agent on a Thursday and I said, we're going to, because I like calling, talking to people. By the way, I write down my notes when I talk to people, right? So, we're going to be doing our physical inspection on Thursday. And the seller's agent says, what physical inspection? I says, well, the buyer has a right to do a physical inspection. And the seller's agent says, they've removed the contingency. And I said, they did remove the contingency, but they still have a right to do a physical inspection. And of course, that was a surprise. And so the agent, the wannabe lawyer said, let me get back to you on that. And so that was a smart move because they must have contacted counsel, probably called Car Legal or something, and were told that don't interfere with the buyer's right to do an investigation. And those are the lawsuits I'm seeing today where the buyer did not do a physical inspection, have an inspection done of the property, and then now it gets, and then they find out after they close the transaction that all these things are wrong with it. And the seller didn't tell them about all those things because the agent, who thought that, non-contingent meant there's no disclosure obligation, kind of had that one wrong. And so, it's a real challenge for us in real estate in that we've got to kind of know what we're doing. And again, I get these calls, I get them from the lawyers, I get them from the, usually defending somebody. But I think I said it earlier today, I have a transaction where the broker has said, we're not going to provide the seller property questionnaire addendum. And it is the standard of care in San Diego County. And I've had the calls from attorneys who said, my broker did not have the SPQA. And I said, I don't know what to tell you. You're in the cooker on that. It's the standard of care. So be aware of that. Okay. It's not a statutory disclosure, but it's certainly a local disclosure that should be getting made. Okay, so again, my buyer went, by the way, and did the Navy SEAL went ahead and did do the inspection of the property, came up with a bunch of repairs, came up with pest control work that needed to be done, submitted to the seller to through their agent to get a credit. The seller gave him 20 grand. Apparently the seller wasn't aware of the fact that they wanted a non-contingent offer. That really bothers me, right? Because the agent represented that the seller was looking for that. And it's possible that the seller changed their mind. There's all kinds of things that could happen with that. But be really careful about writing non-contingent offers. And again, I'll send my material to you if you're interested in it. I'll get that out today. I did write a little thing about the or pull up a little thing about the buyer interest letters, but we'll get back to that in just a second. So let's go back to our presentation and again, my contingent free offer. I'm sorry, there is, so we have, not only does CAR actually has a form for contingent free offers, but so does San Diego. So CAR has the Q&A. Now they've created their own non-contingent offer advisory, which I did not load in here today, but SDAR has an excellent form. SDR came back with this in August of 22, I think it was, and it's signed by both the buyer and the seller. Here we go, August of 21. Excellent form. And again, CAR took a look at it, of course, and said, wow, that's pretty good. We're going to do our own. I use the form that is the standard of practice in the area, so I'm going to use the San Diego form. But again, this explains the dangers to the seller and to the buyer of the buyer writing a non-contingent offer. I mean, creates all kinds of issues for us later. Is everybody okay with that? I'm gonna go ahead and move forward. Whoops, not with that, but with that, I'm going to get rid of that guy, and then I'm going to go back in here to my presentation. Okay, so good. We're moving right along here. Number 3, your job is to advise and counsel. And so all the real estate attorneys that I speak with, what is the agent's obligation? And the agent's obligation is to advise and counsel, right? So your job is to be available for your client. And so my biggest pet peeve is that with agents today, they get their licenses, they're looking for the easy way to make a buck. And so they think that handing everything over to the transaction coordinator is going to satisfy their legal obligation to advise and counsel. So as a matter of example, if you're writing an offer to purchase a property on behalf of a buyer, it's a 16-page document. My non-legal advice would be to go over the document with the buyer, whether you can do it in person or whether you can do it on the internet. Either way, I think I don't think that that's one of these things where you send it to the client and say, here, get this over back to me really quick so we can get the offer in on time for the for the multiple offer situation. I think you really should prep the buyer for these things before they come up. You know what's going to happen. They want to write an offer. Let's sit down and discuss what an offer is going to look like. And again, I love to teach, so I'm going to sit down. But a lot of people are afraid because a lot of real estate agents are afraid because they really don't know what the document says. So I've had my RPA class, by the way, the Department of Real Estate has approved my class for 5 hours of continuing education credit. And I know that San Diego is looking at putting it on their calendar so that we can have, get that in front of you. But I can tell you that a lot of times when agents don't go over the paperwork with the client, it's because they haven't read it themselves. And so, as I always say, the best time to read the document is not when you're sitting in front of the client. All right, but in the old days, we had them on paper and we'd have them in front of us, and I was better reading upside down than I was right side up. I don't know, maybe I'm dyslexic, I don't know, but it was a lot easier because I'd read it so many times anyway. I kind of knew what I was looking for, and all I had to do was look for paragraph 1, paragraph 2, paragraph 3, paragraph 4, that kind of thing. Okay, so but your job is to advise and counsel, and so you review the paperwork with your client. All right, contractual forms. Okay, so the purchase agreement, the listing agreement, these are things you need to be going over with client. I know we've got people out there that are just so busy and they're so good at what they do that they've got a ton of listings, they've got a ton of sales going on. But at the same time, do they spend the time with a client and go over them? I think that the fact that you're busy is not going to be a very good defense at trial. Okay, so contractual forms. What about my disclosures? And so I get really kind of up on my soapbox about disclosures. Let's talk about that in a second here. A lot of times you will have a conversation with the buyer about certain things, like in our case, the seller is refusing to give us the SPQA, and so we're going to have a document, and this document, by the way, is available for you. It's in zip forms. It's under the CAR sample letters, and so if you go into your forms library on the right hand side, you'll see that it has this one. We have one for the buyer, we have one for the seller. So notice to agent or broker. So the first page of this is really an explanation of how to fill out the form. Okay, so and CAR saying, don't sue us, that kind of thing. Letter specific instructions. Okay, again, you're talking to the client about the subject matter, and you're saying to the buyer, I really do believe you need to have an inspection done on the property. And the buyer says, well, I've removed the contingency. And you say, well, that's okay, you can still have an inspection, right? And so, well, what's the point? Well, I want you to know about the property. Okay. All right. So then I have kind of a sample format here, and it says, the two. So this top part is what we refer to as the recitals. And so if you remember your purchase agreement and you remember your listing agreement, these items are at the top of pretty much every form, and those are what links the form to the purchase agreement or the listing agreement. Is the linking mechanism, and again, they're called the recitals. Okay, so down here, acting against the advice of broker, very harsh language, I think. And I'm going to show you Jackie Oliver's confirmation letter in a minute, but here is my real estate sales are very complicated, and so it's come to our attention you intend to take the following actions: write up completely or partially non-contingent offer. And yeah, I want you to read the MCA form, right? Because it's going to say, I don't know anything about the market. I don't know what's coming. I don't know. I know what's been, right? Because that's what I do. I do trial work on that. But you remove a contingency before the time required by the contract. Okay. Failure to make investigations of the property. Close escrow without receiving reports, including the preliminary title report, by the way, which is the subject of the field case, which is something I talk about. In fact, I did that one last week, how to read a preliminary title report. And again, make multiple offers on more than one property. Folks, we've had this conversation, right? When you intend to only buy one. And again, that's my MCA form, which I think is an excellent form, or make an offer with an escalation clause. As a matter of practice, we don't have an escalation clause in California library. In other states where I'm a broker, I have a broker's license, people do them. Okay, I get it. We have more lawyers in California than they do. I probably would not be writing an escalation clause because, again, I think that's legal advice. And so then it says in here, there's inherent risk in the above described action, et cetera, et cetera. cetera. And so by any such, should you take the above described action, you are acting against the broker's advice. Okay, so and then let me know your decision and how you want to proceed. And Jackie Oliver, who I love Jackie. She's an attorney. She's barred in 4 states. She's also a concert pianist, by the way. And she says in her letter that the next time you contact me, I'm going to assume that you have done what you needed to do and you've decided to move forward. And so she just really pins it down. When she writes her letter, and I'm going to show you an example of that in a second, but when she writes her letter, her letter says, don't close the deal. And so we have a broker in our office who called me yesterday about a buyer wanting to get occupancy of a property ahead of the closing, and a long, complicated thing. I won't explain it, but anyway, we have a form called the buyer early occupancy form, and so they weren't aware of it, and so they looked it up, and they go, "Wow, this is pretty powerful." It says right in there, if you move in early, we've told you not to do that. You're on your own, and on and on and on. I mean, all the things that can possibly go wrong and stuff like that. So again, this is an excellent letter, and this is the buyer's letter, right? Then we also have the seller's letter. So in the seller's letter, what happens? I frequently get in the seller's letter, I get you haven't done the agreed upon repairs, you've refused to permit agreed upon inspections of the property, you've allowed the buyer to move in to the property before the scheduled close. Linda, remind me to send this to our guy. Allow buyer to make repairs or renovate the property before the closing, and that includes, by the way, pest work, right? They want to put a tent on the property. That's early occupancy. Okay, so but what's missing from this is, I think, you've chosen not to make a certain disclosure. So like the seller says, well, there was a death on the property. And of course, my first question is always, did you kill her? And of course, no, I didn't kill her. Okay, all right, well, fine. I'm not here for that part of the process, but you need to disclose the death on the property. If it occurred, it's California Civil Code 1710. If it occurred within 3 years, you have to tell them what they died of, unless they died of AIDS or HIV related illness, and then you don't have to tell them what it was. But those are the rules, and it's real simple. I mean, those are, and again, the CAR has a Q&A on it. They've got their disclosure list that also writes that all out. So again, I think you should be giving the buyer and the seller, you need to know what your job is. Okay. And again, I'm not saying this to scare anybody. I'm just telling you that again, I will help you. You need to go to your broker and find out whether or not these things are going to become a problem or not. So I'm going to leave those up there. What else did I have? Oh yeah, we're going to talk about that. Here's Jackie's confirming letter. And again, I love Jackie. She's so great. Here's her confirming letter. And so, and this is, now it's in the library. It used to be kind of hidden behind the firewall at SDAR. I was just so irritated. I spent so much time trying to find it. But look at this. This is really complicated. The real letter is on page 2, but the first part of it is really a great breakdown of, what is it I got to be doing, right? I love this. Boundaries, fences, and easements. You know how many lawsuits I've had where the buyer said, how far back does the property go? And the agent said it goes to the fence. Nah, there were 2 properties before you got to the fence, 2 belonging to somebody else. And so physical inspection reports, disclosures, new facts, zoning, tax, or legal inquiries. Okay, so that's the gist of, these are the things you need to be talking to your client about. The assumption there was the buyer, but we also have this for the seller. But here's my language. It says right here the basics of your conversation. So my letter, and by the way, mine is an email, and my email will say something along the lines of, thank you so much for having that great conversation we just had a few minutes ago on the phone. And in that conversation, I told you really need to get a physical inspection done of the property by a licensed contractor. And you have chosen not to do that. And that's what Jackie's letter says. We don't give tax, legal advice, et cetera, et cetera. but and actually she's changed the letter. I'm looking at it now. So, but the crack in the floor, things like that. Anything that's really a material fact, anything that's a big deal, you need to document, memorialize it, so that you told them to do it, and then if they don't do it, then that's up to them, right? So please contact me after you further investigate these issues if you have further questions. And so, in other words, I don't want to hear from you unless you've done that, okay? But again, her letter in the previous iteration of this was pretty much, I told you not to close the deal, and you're going to choose to close it anyway. So that's going to be on you. So interesting, the perspective of that. But again, Jackie's a practicing real estate attorney, so she's in the streets like me. We're in the streets on this, and so we want to make sure that we protect our client. And a lot of times we're protecting ourselves from our own client. Okay, everybody good with that? One other disclosure item, and this is something that I know that the interesting part about our transfer disclosure statement is that it changed. A lot of people aren't aware of that, but the original law came into effect in 1987. It was really a function of the Easton case, we call it. I've done quite a few talks on that now, but the Easton case resulted in Civil Code 2079, which is the one that we are obligated to. And again, you can find out what that says just by reading the agency disclosure form. But the TDS has changed, and so there's a blank on the first page, up towards the top of the first page, that says used to have two items. One of them is disclosures required, or given by another report. I mean, there's two of these blanks, and it goes into it here. But then the third one is a substituted disclosure. I'm sorry, all three of them are substituted disclosures, but they've added the one part, and that is no substituted disclosure, because the way the legislative body looked at it, they said, well, nobody was ever checking any of the boxes, and the legislative body said, no, somebody's got to check a box, otherwise we have an incomplete disclosure, otherwise known as a defective TDS. You don't want a defective TDS, folks. Remember, the buyer has 2 years to sue on a defective TDS, and again, the defective TDS is an incomplete TDS, essentially. Okay, all right. So NHD report should not be considered a substitute disclosure for a bunch of reasons. So all kinds of stuff in there. So this is a really good article that CAR wrote, and I always send this over to our sellers when they are completing the transfer disclosure statement. Our agent is with them at the time, going over how to fill it out, or they're on the phone. Or they're on the computer on the internet with them, but I always send this over to explain the issue behind the reason why they have to check one of those boxes. Everybody okay with that? We're going to start moving a lot faster, by the way. I know you're looking at your clock and going, oh my God. So your job again is to advise and counsel. So the disclosures are a big one. Your warnings, your market conditions advisory, your cyber crime warnings, your wire fraud advisories, things like that. You need to be doing those with your client. I had a lawsuit not that long ago where the buyer's agent's defense was that I told the buyer to contact me if they had any questions. Well, that's not going over the forms with the buyer. That's you not doing your job. And I've had it happen in trial where the judges turned to me while I'm testifying as an expert, and the judges turned to me and said, why do they shirk their 2079 duty of inspection? And it's like, I get it. Okay. So the preliminary title report, I mentioned the field case earlier. Right? Remember the field case? And so the field case was a situation where the buyer didn't even get the prelim until after closing. Well, that should not have happened, right? Because in that prelim, it showed, and again, I did this talk last week. You can pull up the webinar on that. But in that webinar, in that prelim, it said that the city, the Otay Water District was able to dump a water tank on an adjoining property, and that it would flood the subject property, the one that the buyer was buying, including the house. So including the dwelling, as it said in the prelim. And so, the buyer, of course, doesn't get the prelim until afterwards. So clearly the agent didn't explain it to them. And so the buyer, of course, had a problem with that. And so and here come the lawyers, right? And so needless to say, that went all the way up to the appellate court. And the judge in the appellate court level wrote what we call dicta, which was really damning for the real estate agent because, first of all, they shouldn't have allowed the buyer to close it without the prelim. But secondly, they should have known how to explain the prelim to the buyer. And most people I know don't know how to do that. You watch my video and you'll know how to do it. I just think that's the easiest way to do it. So physical inspections, again, remember that when you go to a physical inspection, the inspector goes right, you go left. You don't want ever to have your report, his report or her report be a substitute for your report, okay? Yours is a duty to inspect. His is a duty to investigate. The buyer's duty is to investigate. The agent's duty is to inspect. The seller's duty is to disclose what they knew or should have known. Everybody okay with that? All right, so that's my physical inspections. And again, if the inspector says one thing, don't contradict what the inspector says, okay? Because why? Because you're not the inspector. And they have insurance for making mistakes, and you don't have insurance for making a mistake on a physical inspection. That's not in your licensed activity. Do your own avid. And I'm realizing I did not pull up the Avid, but the Avid, I am going to go pull up the Avid. I think the Avid's a great document. It really is. And it took care of a lot of problems that we were having with agents just saying, recommend buyer get physical inspection by licensed contractor. Well, again, remember the judge, why are they shirking their 2079 duty? And so we created the form so that you really can't answer no items noted for disclosure on the TDS, right? So let me pull that up. I think it's important enough that we do need to look at it. I'm going to go up here to the CAR website and pull up that form. Okay, so good. You get to see my username and password. Not really, but okay, you can see my username. There we go. And then I'm getting really good at this, by the way. I'm on this all the time too. I'm in the MLS all the time. I'm on this all the time. So I'm going to go up to our template. So we have a template, and everything we do is by templates, right? So I'm going to click on templates, forms and checklists, and I'm looking for my TDS. So where's that going to be? That's going to be under my seller listing template, right? So the transfer disclosure statement. I'm going to pull up TDS. And then there's my TDS. So there's my quick guide. You see the quick guide? So I have that in like I said, I told you, I send that to the client, at the time that they fill out the transfer disclosure statement. So I'm going to fast forward to page 3, which is the part where you do things. And here is page 3. Okay. So page 3, see attached agent visual inspection disclosure. In our office, we pre-check the box. Our agent will fill out an avid. Okay. But I've seen people check the box. Agent knows no item for disclosure. Not in our office. Again, I'll go out to the house with you, and I assure you, you're going to have pages of stuff. I had one recently where the broker put in, check the box and said, recommend physical inspection by licensed contractor. And again, that's a problem for the agent, but again, they're the broker. It's not my place to educate them. In fact, they got into a big argument about it. So anyway, my avid is critically important, and that's why we have that box checked already. So let's go ahead and let's take a look at the avid. See if I can get to it this way quickly or not. Obviously, I've got a lot of stuff in there. So there's your acting against advice, seller. Again, this is the seller side of the transaction. There it is right there. Okay, good. All right. So I'm going to pull up my avid. My avid, again, remember I said earlier, Civil Code 2079. Folks, this is how you just keep yourself from getting into trouble. Okay. So, you go through the avid. It's got all kinds of great stuff. I mean, the last lawsuit I had where the buyer claimed that the agent didn't tell him about stuff or the seller didn't tell him about stuff. And here, this paragraph, what this means to you. And this was the part that said that you need to review, the buyer needs to review the disclosures, and whatever I do is not a substitute for their investigation of the property. So very, very, very important. Okay. Anyway, so this is the avid form, but I wanted to also show you that we actually have a Q&A on the avid. And that's this one right here. So the agent visual inspection and disclosure form. And yeah, you know what? It is the law. Technically it's not the law, but maybe it is now. I don't know. But sale of residential 1 to 4s, you do have it. The law is clearly the law says you have a duty to inspect and disclose. Okay, not investigate. All right. That's why they changed the name, by the way. Remember what used to be the buyer's inspection advisory now became the buyer's investigation advisory, because that's the buyer's obligation is to investigate. Okay. All right. So what do you got to do? And so this is the language right out of the TDS, right? It says conduct a reasonably competent, diligent visual inspection of accessible areas of the property, right? And to disclose to the prospective buyer material facts and defect that should have been discovered during the inspection. Okay, and so this is a great narrative. And in fact, I'm thinking I'm going to add this into our template for our agent to know what to do in a transaction. Forms, the TDS and the AVID, the advantages of the AVID, all this kind of stuff. Okay, I've been around long enough. I've seen real estate agents have their transaction coordinator fill out the AVID. I think that's incredibly dangerous. So I wanted to let you know about that, but you need to be thorough within your field of expertise, right? And I'm going to tell you to upload photos. And so this is one of the coolest things. Watch this. I'm going to pull up the AVID, and I want you to notice up here, see where it says photos? Everybody see that where it says photos up here at the top? When I click on that, it says attach photo, detach all photos. I'm going to attach photo, and it's going to pop up my window. Oh, there's my law class. It's going to pop up my window that allows me to attach a photo. So when I'm doing my AVID, I'm walking around, and let's cancel that. When I'm doing my AVID and I'm walking around and I see a picture, I see something in the living room, right? I'm going to go ahead and I'm going to take a picture, and guess what? I'm going to upload it. When I upload it, I'm attaching the photo. You follow me here? Attach the photo, right? And when I attach the photo, now it's going to be part of my AVID. So this is the only form in here that I'm aware of, certainly, that works this way. But this is a huge deal, right? So, you're going to put in your AVID that you saw, stains on the wall, and you're going to take pictures of the stains. You're going to memorialize them forever. Okay. So, this is really critically important. All right. And so that's what I love about this class. I love the AVID. I just think it's a great form. And I'm glad we came out with this. It's probably only been around for about 15 years or so. But I have people today who don't want to fill it out. And it's like, okay, you're on your own. By the way, one other thing, talk about risk. I get down here to this box on page 3. So again, based on a reasonably competent, diligent visual inspection of reasonably and normally accessible areas of the property as of this date. Okay, and then notice what it says: signature of whoever performed the inspection. Okay, and the DRE has said that they're looking at teams, right? Because the team, it's got the team leader's name, but the team leader did not do the inspection. An agent went out and did the inspection, but then the team leader signed it, and the Department of Real Estate says we think that's fraud. When they use words like that, I just like, oh God, you've got to be kidding. You're absolutely right. It says who performed the inspection, right? And so I had a property that I had listed years ago. I don't compete with our agents, but I had listed a property, and one of our brokers was with me at the time of the listing. This is up in Lake Forest. And our broker, while I'm talking to the seller for 3.5 hours, getting the seller's disclosures all completed, the broker that works with us under Linda's license went around and did the AVID on the property. Well, his name appeared here and he signed it. So my name did not appear there because I didn't do the AVID. Okay. The agent, Linda, did the AVID, right? So Joe actually physically did the AVID, but Joe's a broker under Linda's license. I'm a broker under Linda's license. So the important part there was the person that does the inspection is the one who should sign it. Does anybody have any questions about any of that? It's very, very important. Okay. Did I have any questions up there? Seeing none. Okay, then I'll keep going. All right. But again, please ask questions, because that's what I'm here for. I really want to make sure that all this stuff is fairly self-explanatory. Okay. So okay, I'm going to go back over to my PowerPoint. And so again, upload photos. I just think that's the way to go, right? Be sure you have a written agreement with your client. I mean, this goes without saying, right? When I'm representing the seller, I'm going to have a listing agreement with the seller. Now I'm going to tell you, and I'm telling you now, this is going to hit California by storm. Okay, I was on a call 2 days ago now with the brokers of a bunch of really big companies in California, and it was interesting because I was asked by NAR, and it was a National Association of Realtors meeting for the delegates from California, and so actually from the Region 13 we call it, so California, Hawaii, Guam. So the question was, about the buyer representation agreement. And so I was asked, whether or not roughly what percentage of buyers are being asked to sign the buyer representation agreement. And so I said, I'm going to tell you about 5%. I think that's really sad. And part of the reason is because agents don't understand it. And again, I teach it. So I'm having that course approved by the Department of Real Estate as well. I've got to back up with them, find out where they are on that. But at the end of the day, buyer representation agreement. And so all of the brokers agreed that you have a contract, you have a written agreement with the seller by virtue of the residential listing agreement. But what we see now, because remember, your MLS rules across the country, and Bright MLS on the East Coast just changed their policy because remember, there's no minimum, no maximum amount of commissions that you can be paid for a real estate transaction. And so and you are the victim of whatever the seller's agent has negotiated with the seller. And we find a lot of times the commission we get is very different than what the seller's agent took for themselves. And so but at the end of the day, we're seeing listings in the MLS at a penny. And so, you know, if you're gonna do the transaction with all of your heart for a penny, and that's what's starting to happen across the industry, because there is no minimum. And so sellers agents are keeping, you know, a different number for themselves, whatever that is. But again, you need to have a written agreement. And if you're not good at doing that, you need to get good at doing that. And we all agreed the same thing. You need to have a buyer representation agreement. And again, a couple of the people on that committee, on that meeting that I was in, were on the committee that created the new buyer representation agreement. And of course, they totally agreed with me that you need to have a written agreement with your buyer. But we as real estate agents think that it's about the commission. Forget the commission. Talk about why you want the agreement. And it's not just the commission, right? It's because you want to create a contractual relationship between yourself and the buyer. And by the way, on that form, it does say to the buyer, here are the things I'm going to do for you. I've had more than one attorney tell me that they can't sue you for what you tell them. And so here's what I'm going to do for you. And it says it in writing on the form. And then they can't come back later on and say, well, I thought you were going to do this. It says right there, this is what I'm going to do. I'm not going to do that. Right. So that's one of the reasons why, and I get real adamant about it. In our office, everybody, you know, we just all have them signed. I mean, there's no question. Right. And so in other states where I teach, for example, in Virginia, the broker won't pay you unless you have one with the buyer. So it's just in the state of Southern California that we have a problem with this. So, but you're going to have to get good at it, folks. And if you, and you know, hear me now, because this is going to be a huge deal. Bright MLS just changed. You know, they used to have there was a minimum commission of a penny. You can't have a minimum commission. So they said, hey, you know what? You're right. So they changed it to 0. You can put in the MLS, you get paid 0. And your buyer says, I really love that property. And you say, well, I'm not going to get paid if I represent you. And they go, I don't care. We love the property. And then what are you going to do? Drop kick them up to the seller's agent, have the seller represent them? No, you need to have some kind of a written relationship. But again, we want to define the duty, define what we're going to be doing. Okay. And so, and I use this is a quote of mine: when you define your duty, you limit your liability. Okay. So DDLL, I made it up one day, probably 15 years ago. And everybody, you know, half the place was full of lawyers and they loved it. Okay. So just remember that you need to define your duty. In the law class I'm teaching right now, I have them write out the paragraph on the buyer representation agreement. I have them write it out, you know, the different things that the agents do for them. And so, and the lawyers, they go, wow, why'd you have us do that? And then after they do, they go, I see why you had us do that. You guys work hard. Yeah, we do. Use a checklist. All right, real important. Use a checklist, especially check with your broker. So if you have a broker that provides one, you definitely need to use a checklist. Okay, so let's go back for a second here. I'm going to take us back to the program, and I'm going to take us back to the forms part of it. So here we are. Here's my seller's listing template. I'm going to remove my TDS, for example. And notice up here, question, Dally, how can buyer's agent negotiate commission with a seller's agent prior to acceptance of the offer? And the answer to that, it's an excellent question. It's a 400 level question. Absolutely. So let me say it again a little bit slower. So can the buyer's agent negotiate a commission with the seller's agent prior to acceptance of the offer? You have all the right elements in there. And the answer is yes. And the way that we used to do that is we used to use the CBC form, the Cooperating Broker Compensation Agreement. And so we see this all the time. We get, you know, we're going to write an offer for our buyer, the seller's agent's paying us I don't know, I'm going to make up a number, 2%, but we work for 4%. And so we go to the buyers, they go to the seller's agent. We say, we're going to write an offer on your property, but and again, you can't make it look like extortion, but we're going to write an offer on your property, and we work for 4%. You're only paying us 2%. You'd be shocked at how many times I've had people agree. I had a listing up on Lawrence Welk. I had a buyer for a property up in the Lawrence Welk Estates, and so I'm writing the offer for the buyer. I send over the CBC form. So that was the other part of your element here, is prior to acceptance. So prior to negotiation. So I sent it ahead of time, and we have a fix for this today, by the way, and I'm going to show you in a minute what that looks like. But again, I sent the CBC form over saying, pay us 4%. I've never gotten one back so fast, agreed to by the seller's agent. And so, we got under contract, everything was fine. Again, I can't bring this up, after the deal is done, right? Once the deal is accepted, it's inappropriate for you to hold the transaction ransom. Okay, that's inappropriate, probably code of ethics violation. Okay, we're not going to close the deal unless you pay me 4% or whatever. Okay, so that's a big no-no. But before the transaction, absolutely. Okay, so this gets even better. I love your question. So I get this thing back. I mean, it was so fast. 2 weeks into the transaction, I'm there at the property with the other agent. We're doing the physical inspection and all that. And I said to him, I said, I've never got one of those back so fast. What's going on? And he said, out of earshot of the seller, he said that the listing was expiring next week, and I've had it on the market all this time. It wasn't selling. And so we were looking for, an offer, but the seller told me if it doesn't sell, we're just going to stay here. And so the agent said, my theory was I either get paid a little bit less because he took it out of his commission, gave us what we were asking, rather than get nothing at all. So it was either all or nothing. And so, I thought, wow, that was pretty smart, right? But and the deal came together because the buyer and the seller wanted the deal to come together. But that's an example of sending that CBC form over in advance of the offer. Now, and I know today everybody's, oh no, we never do that. Yeah, we do. I mean, you got to understand that you got to be professional about what you do. And if you think you're worth more money, then you need to absolutely have, ask for it, right? So let's take a look. I want to show you the new purchase agreement. And this is how we're doing it today. So how our office is doing it today. So in your purchase agreement, you have a paragraph. I probably should pull up the buyer's template, but in the purchase agreement, you have a paragraph. Here's 3G3. Yes, I have it memorized. So there you go. 3G3, seller agrees to pay the obligation of the buyer to compensate the buyer's broker. Buyer's broker. Oh, wow. Under a separate agreement. And so we're going to include the SPBB form, right? Okay. So we've been doing this ever since CAR changed the purchase agreement last year in anticipation of that NAR DOJ outcome, the lawsuit going on there. Okay. And in fact, I just read today that one of the lawsuits against, the defendant happened to be Berkshire Hathaway. It didn't have anything to do with Berkshire Hathaway. It had to do with the industry and how we do things. And so that lawsuit's going to move forward. I don't think it makes it on the merits, but okay. But this is how CAR counsel wrote the contract to have the buyer who has a buyer representation agreement. My buyer has a 4% buyer representation agreement with me, and now we're going to have the seller pay the buyer's obligation. And so we send over the SPVB form. Seller says, okay, fine, I'm okay with it. A lot of times the seller really doesn't understand how much is being paid to the buyer's agent, but this is part of those disclosure requirements. And so we used to do the CBC form. Now we in our office are doing the SPBB form. The seller doesn't have to sign it. They can say no, right? But in every single case, I've yet to be refused. In every single case, the seller has signed it. Okay. In every single case, we've gotten paid. Okay, so Dal, your question's a really good one. It's a multi-pronged question. I can't see. I'm hoping you can see the screen that it shows. Gosh, I hope you can see that. Can you? Yeah, you can see it. Okay, so the paragraph 3G. 3G3. Okay, so 3G3, and it's one of my favorite paragraphs in the new purchase agreement. And it says, and by the way, you have to have a buyer representation agreement. Don't say, that they're going to pay for whatever that agreement is if the buyer hasn't signed one, right? But this is what we have a conversation with the buyer. We say, we're going to do a buyer representation agreement. We're going to go to the seller and we're going to ask them to pay the compensation that you've agreed to pay. Okay. And so that's how we get paid. But again, remember that 1 cent listing, and again, remember Bright MLS on the East Coast, which is most of the Eastern Seaboard, by the way, is they've come back and they said, no, we got to put in a 0. I mean, we've got to leave a space that'll allow a 0. Does that make sense to everybody? Okay, all right. It's just part of the nature of our business. I don't know. I kind of believe in the concept that the buyer should have a separate contract with the buyer's agent. And so there you go. Okay. And so commissions are a completely separate issue, but we try to make it about commissions and we make ourselves crazy and all that kind of stuff. But at the end of the day, nah. So again, the checklist, which was what I was starting to show you in the first place. So let's go back up here. So CAR actually has a checklist. I got to go back to the forms part of things. Clicks the back button. He says with confidence. I'm in the templates, so I need to actually go to transactions. So in the transaction file, let's just open one up, one that's from years ago. Notice up here at the top, let me see if you can all see this. Yes, you can. Okay, so notice up here at the top, it says checklist. So I actually kind of like the checklist, the one that CAR provides. If your broker provides one, you absolutely need to use your broker's checklist. But this is a good one. This is one, when you write your offer, it automatically populates the time periods from your offer, whatever the pre-printed language was. And again, if you've changed it from 17 days to 15 days, then you just change the date on the calendar. But this is not a bad checklist. This is the month, right? Who's responsible for it. It could be the buyer, the seller, whatever, right? And all that kind of stuff. What's urgent, what isn't. Can I create a new checklist? Yeah, I can do that. I can do all kinds of stuff. So again, excuse me, again, I think that this is a great opportunity for you to have a checklist. Excuse me, you sneeze on the truth. I'm sorry about that. That really stuck up on me. So, okay, everybody saw what I said, what I showed you though, that checklist thing. And again, we're a transaction management company. So, we have checklists but we know them in our head. So, and we handle transactions for a lot of brokers. Okay, so especially if your broker has one, remember that you are the captain of the ship. And this is really, really important. So you are the captain of the ship. I get this all the time. Do not rely on the transaction coordinator. I'm sorry. I mean, listen, I know a lot of really good transaction coordinators, but if they make a mistake, you're going for it. Okay. And so, like I say, I know some really good TCs and I know some TCs that really should take more classes. But the defense that I gave everything to my TC is not a good one, unless, of course, your broker instructs you to do so. So if you've got an in-house TC, I would use the TC, right? I was with the Rock people back in the early 90s, and that's where TCs came from, where we were starting to pay more and more commission splits within the brokerage. So we found our agents becoming less and less diligent about the forms being completed or the forms even being provided in the transaction in the first place. And so what we did was we created the concept of TC. We would charge our agents, I think it was $125 to use the transaction coordinator, but it was really for our benefit so that we knew that we would have a full file. Because one of the hardest things you ever get from a real estate agent, especially after they get paid, is the rest of the paperwork. Okay. So that's why we created that. And so I always told people, at that time we made it mandatory. Then as time went on, the agents started kicking that bill up to the buyer or the seller. So, and at the time, the Department of Real Estate said, well, if you have it in the listing agreement, then you can charge for it. But remember, you have to have that language that says all commissions are negotiable, and that includes any fee charged by the broker. So the listing agreement contained it. Oh, and by the way, the buyer's agreement contains it. Okay, so if you're going to charge a fee, it needs to be in a written agreement along with with that language. Now fast forward to 2018, and I'm in a meeting with the district manager for the Department of Real Estate, and she says, we think that that's a junk fee, or otherwise known as a garbage fee, that that should be what you are making, what you should be doing for, your commission, which, you're just going to have to eat the cost. And so we took that out of our documents right away. We said, oh, forget it. We're not fighting with that. Right. So we took, listen, I got a lot of respect for the Department of Real Estate. Okay. And so we took that out of our contracts with our buyer and out of our contracts with our seller. We said, no, we're not going to do that anymore. And so we haven't done it since. So now within our company, our agents charge a reduced fee, a small fee, but that's just for file review essentially. But with other companies, maybe they do it differently, I don't know. But if you have a transaction coordinator within the company, you're probably in better shape than if you have one that you use that is outside of the company. So let's talk about that. So if it is an in-house TC, then you might have some protection. Why? Because they're an employee of the broker. And so as a result, you should have insurance coverage for that. Okay. But if they are a TC from outside of your brokerage, well, that's not going to apply, right? Because they may or may not have insurance. And I had a transaction coordinator get really angry with me. She said, you just cost me a whole company. And I said, how's that? And you made a comment in a meeting that said that they needed to check, everybody generally needed to check to make sure the TC had insurance, right? And so there it is. Get approval in writing from your broker. First of all, make sure your broker's aware of who you're using. And as I said, there's some really good TCs out there, and be sure they have E&O insurance, and again, that indemnifies you, but also your brokerage. And so I made that comment in a meeting or a class that I was giving, and of course, she lost this huge account. I said, well, you don't have insurance? She says, no. I said, why not? She said, I can't afford it. I said, for what you charge, then you need to kind of step it up. Maybe you need to charge more. Maybe you need to have them pay your E&O. But there is E&O insurance available for transaction coordinators. So if it's not within your office, then they need to prove to you that they have insurance. Okay, and so that's just something I stick on, and it's just one of those issues. But again, do they make mistakes? Oh yeah. And when they do, it's a doozy. I actually had a lawsuit that it was a fascinating lawsuit for me, but it was where the agent had left the company that they were with, and they opened up their own company. They were a broker, opened up their own company, and then they used the transaction coordinator from the company that they used to be with. So again, that TC covered by that insurance, but now they're with a separate company, and the TC is helping them on the transaction in this separate company. By the way, that insurance policy does not cover the TC's act with the other brokerage, right? Because it's covered under their company, but they're not in the company anymore. And so now the TC is doing, essentially, I had a real estate license, essentially doing license activities with the new broker. And so I'm seeing these emails back and forth, and it was like, oh my God, I mean, seriously? So legal advice all over the place. So be really, really careful about that, folks. I don't want you to get in trouble. And again, I'll have an agent tell me in the beginning of a transaction, send everything to my TC, and I'll respond. I'll say, okay, I'll tell you what, I'll send everything to your TC, but I will copy your TC. I will send it to you first. And then the TC will be in the copy field. Okay, much like I copy our agents in the CC field. Okay, so now they get annoyed sometimes. I don't want to see any of your stuff. I'm going to block it. But I'm going to be able to prove I sent it to you. And so sometimes I'm going to be saying stuff that is there for your defense. And so maybe that's not going to work for you. So is everybody good with that? Questions on any of that? Document, whoops, question. Yes, please. Sorry. Yes, absolutely. Right. Oh man, if I can tell you, listen, folks, I like going to court. There's a lot of money, and I get $4.50 an hour. And Linda says, is that $4.50? I go, no, that's $450 an hour at trial. And so they want to do everything they can to keep this thing from going to court, because if it gets to court, now I really get expensive. Okay. So yes, absolutely. So document everything. Okay. Remember, I've already shown you the against the advice of the buyer, the buyer, the seller letter, the confirming letter. I've shown you all these things. You need to document everything. And by the way, load them into your transaction platform. And I'm going to show you how to do that in just a second. I'm assuming you're using zip forms, but you could be using SkySlope. You could be using Glide. But load everything, emails, telephone calls, text messages, and I have a little asterisk next to text messages. And so load everything into your transaction management. So let's go back over here to my transaction. So again, I'm in the transaction. I'm going to pull up the documents, and then I see that, you know, I'm going to probably send. So like, let's say I'm going to pull up a agent's visual inspection. I'm going to send it to the other agent. And so here's how I'm going to do it. I'm going to click the send button. Why do I do that? Well, the reason is because over here where it says history, wherever it went, where did it go? It hasn't done it yet because I haven't sent it yet. But anyway, it says history. I'll see everything I've done. So I have a record of everything that I've sent. So I don't even use my email program anymore. I use this. Because otherwise, if I use my email program, now I got to PDF all of my emails and then load those into this file. And so how do I do that? I'm going to go back over here, see where it says add document. So that's how I'm going to do it. Now, this one happens not to have our folder in it. This transaction occurred. In fact, this one's already gone away. But let me see here. Let me get you. I had a sample transaction for a while, and where did it go? Inactive, maybe. Trying to find it here. Inactive. Come on. Okay. So I had a sample transaction. All right, I don't see it. Well, let's look at Carmel View. So anyway, in my and again, I do templates. And so when I go to documents, and it doesn't have it either. All right, so let's do it the easy way. Let's go back to my templates, and I'm going to do my buyer offer, where here it is, buyer offer template. And see these folders here on the left-hand side? Those folders are very, very important to me, right? Because this is, for example, here's my conversation log. So when I'm having to PDF my emails, I'm loading them up into here into the conversation log. So I love it. Most real estate agents, you know, when I'm doing a transaction with them, especially if they know everything, they don't want to talk to me, right? So they'll send me an email. Oh, hallelujah. I love the emails, right? Because I'm going to load everything in here. Okay. I can also, by the way, you know, get out of here, and this doesn't have it, but it has that notes field. So when I'm in a real estate transaction, I can go back over here and let me just pull you up one here. But see right here where it says notes, and I'm going to click on notes. And then every time I write a note, now this agent's not doing notes in here, but they're emailing. And so they just, you know, create a new note. There it does. Times date stamps it. Everybody okay with that? Remember what I was mentioning about history earlier? Here's history, everything that's been done, all the transactions, all the informational paperwork going back and forth between the parties. And then under parties, I don't email them forms anymore. I go to parties, and you see this button right here that says share. I'm going to click on share. Okay. And so this is where I just add all the documents that I want to share with the individuals in the transaction. So again, I haven't, unfortunately, I haven't taught the zip form class in a while. SDR hasn't had me doing that, but I think we're probably going to see me doing that again. I show you how to create templates. I show you how to do all kinds of stuff, but interesting enough, I was on the phone yesterday with the only guy, the head of the program, the head of the Zip Forms program at CAR, and I told him, I said, I found the documentation, including the CD of when I was teaching it when it was called Win Forms. So that tells you how far back that goes. That was 25 years ago. I was teaching, or not quite 25, 20, yeah, almost 20, yeah, 25 years ago. I was teaching Win Forms. I actually found the original stuff, and he says, I said, do you want it? And he says, no, we look at that stuff every now and again, we laugh about it. And I go, yeah, I get it. Okay, so folks, again, back to our PowerPoint. So I'm going to load everything in there, and then I've got that asterisk next to text messages. We're going to talk about that in a minute. I think you need to maintain good communications. All right, and so be careful what you email. Certainly when I was teaching in college, in the colleges, I had 150 students at any one time, and I just always assumed that any email I got after 9 o'clock at night involved alcohol, because I got some doozies. And so you know, so I just always, you know, be careful what you write. And if you are not in the right mind, and whether you're angry or whatever, you might want to step back, count to 10, and I always have, when I get angry, which is never good, I always ask Linda to check it out. So Linda will, you know, I'll send it to Linda first, and I'll say, is this okay to send? And she'll say, you're right, like a damn lawyer. And I go, well, I am a damn lawyer. So I'm just not an attorney. All right. But, you know, listen, So be careful what you email. Remember, and I had an attorney tell me this probably back in '96, and he said, just be careful, email is forever. And I said, I got you on that. And then I say here, do not text in a business relationship. So if you attended the panel I was on with the district manager for the Department of Real Estate and Gov Hutchinson and Robert Sunderland, who is Cress's attorney, we all agreed at that panel that, back when I was president of the association, we all agreed, do not text with clients. So I text with family and friends only. I don't text with clients. And people all the time say, I've been texting you. I go, I didn't get it. And they go, why not? And I go, I don't text. And they go, well, now you're not returning my calls. I said, yeah, because my program automatically blocks people that text me. so which is not 100% true. Usually I call them back, but somebody sends me a text message, I just call them. I get them on the phone. I go, are you trying to get a hold of me? And they go, yeah, I sent you a text message. I say, well, I don't do text. So what's going on? Okay. So, but I would not be texting in a business relationship. I could do a 2-hour class on that subject. Okay. Be the source of the source, not the source. So again, remember my example of the city of Del Mar. I don't want to be the source of the information. When the buyer says, can I build a 2-story? I don't want to answer, yes, no. I'm going to say, hey, that's a really good question. Let me find out. Okay, here's the phone number. Give them a call. I had a really good conversation with them. And when the buyer says, what do they say? I said, I don't remember. And a lot of times buyers will, especially me, buyers will ask me, will go, well, legally. And I go, I can't answer that. You just said legally. So as far as I'm concerned, an illegal is a sick bird. Okay. So all business communication should be documented via email. 10-4, Dal. You are absolutely right. Email everything. So that's why I said a second ago, when the agent says to me, when the agent stops talking to me, and that's because, I don't know, I intimidate them. I don't know what that's about, but now they do everything by email. I go, good. Exhibit A, Exhibit B, Exhibit C, everything goes in the file. And they don't realize I'm building a hell of a file. Remember what I said earlier, the Department of Real Estate has an obligation at law to respond to all complaints. And that's not one you want to get from me because we're friendly. And so, but I got a couple of them that I'm not happy about, but like the seller's agent saying that the seller's in trust, they're not obligated by law to disclose, to do any disclosures. And I said, I don't know about that. So anyway, I have lots of documentation that says we were trying to get it from them and they wouldn't give it to us, but whatever. Be proactive in addressing complaints. The number one complaint against realtors, by the way, the number one complaint against attorneys, they didn't return my call. Okay. And so I need you to stick your head in the mouth of the lion. Okay. And again, after you check in with your broker, if somebody's got a problem, you need to, get what the problem is, contact your broker, and then the broker needs to tell you what to do. But here's what ends up happening. If you don't respond to them, then they meet the cocktail attorney. They're at a party of some kind and they start talking about, I'm unhappy about this transaction, my agent this, my agent that. And so then the attorney says, well, they can't do that. That's against the law. And so that's okay for the attorney to say that. It's not okay for me to say that, right? But I'm going to tell you, you don't want them talking to the cocktail attorney because clearly they're drinking, and you want to have some handle on that conversation. So you need to call them. I had a lender who was doing almost all 95 loans a year with me because we don't do loans, so they were doing loans. So we would send stuff over to them, and so she never called me on the phone and said we've got a problem. Because I don't want to hear it, right? Not my problem. I don't do loans. You do the loan. She would call me on the phone. She would say, here's what happened. And then here's what I did about it. All right. And that's kind of my way of doing things is here's what happened and here's what I did about it. Or here's who you need to contact. Here is my confirming letter. Okay. All right, good. Okay. Conversation log. We talked about that. You need to, so first of all, 100% of the broker files that I review don't have one. All right. Now remember my template. So go back up here to my template. And when I pull up my template, remember that I have under my seller listing template, buyer offer template. Here it is, conversation log. There's nothing in there right now because this is a template. So, but we have this folder that is our conversation log. So everything goes in there. I click on the folder, I click on add document, and it says, where is it? And then I pull that email in, or I pull that writing. I was taking notes. I remember I was with one of my attorneys. We just left a football or Padres game, I guess it was, at the old Qualcomm Stadium, and we had left. And this agent calls me on the phone, and before I had a chance to say, I'm with one of my attorneys, he just starts getting into this stuff. And I'm just sitting there, okay. And they carry on this conversation. And after the conversation was over, my attorney turned to me and says, "They talk to you like that?" And I said, "Sometimes." And so I wrote everything down, right? But now I also had a witness. And so, if I ever had to go after this broker, I got a witness right here. Here's what you said, and here's my witness. And by the way, they're pretty unimpeachable, right? So be careful. And clearly, I always ask the question, who else is in the room? Whenever somebody has me on a speakerphone, who else is in the room, right? Can anybody else hear this conversation? So, because I want to know, not that I'm going to hide anything or not say something, but I want to know, and I'm entitled to know. So I ask the question. Okay. All right. So 100% of the files that I review don't have a conversation log. In the old days, and I just threw a bunch of them out. In the old days, we used to staple the conversation log to the front of the manila folder, right? And then we would, date, time, that's all you really got to do. Or send that conversation that I said earlier. Thank you so much for taking my call today. Here's what we talked about. And then if any of the above does not comport with your understanding of that conversation, please let me know immediately. And then 3 years from now, when they filed a lawsuit, I've got, that in my notes that's, you didn't get a hold of me for 3 years. So obviously it took you long to get mad. And so there you go. Make certain that your key transaction decisions belong to the client. Remember, the client is the one who is in charge in the transaction, not you. All right. So again, acting against the broker's advice, we want to make sure we've had this conversation and then they went ahead and did what they wanted to do anyway. Okay. All right. What was this one? Buyer interest letters. We talked about that already. Fair housing. So don't write those. Those are not good. Okay, so make sure that the key conversations belong to the client. Be careful that you don't know too much. I have many a transaction. When I get the lawyers sending me stuff, they show up at the front door with a FedEx box with boxes filled, the dolly with 6 boxes on it, filled with email. It always makes me proud because if I've got all those emails, I know I've got a really good defense, but it's the one that the file's this big, that's never going to be good. Okay. All right. Send confirming letters. We already talked about that. Certified mail on key decisions, although in the immortal words of Jackie Oliver, emails may be okay if you get a written response. And so again, if any of the above does not comport to your understanding of that conversation, please let me know immediately. And if you don't let me know immediately, then, and again, by the way, I sent it to you to the same address that we've been talking through the entire transaction. So, it seemed to work okay before, but of all the emails, you didn't get that one. No, that's not going to work. Okay. And listen, I deal with people that got AOL addresses, they got Yahoo, they got Prodigy, people that really don't do email, but they're using or Gmail, they're using the free email services. I really think they should be using the company's email because that at least will give you some defense. And by the way, E&O carriers are denying claims. And I had this conversation in that meeting at NAR 2 days ago. Some insurance companies are denying claims if you didn't use the company's email address, because the company keeps copies of all that. And so if you didn't use the company's email address, they're going to look at your Gmail and think that maybe it got hacked or something. So very, very important. So SDAR has risk management forms. I've already shown you all those, the confirming letter with Jackie. And then finally, my favorite, this is certainly my favorite. Well, first of all, questions about anything else? I'm going to use that for get a drink of water. Questions? Seeing none. And by the way, thank you for your feedback during our presentation today. The 3 most important words in real estate, and again, on the state exam, they tell you that it's location, location, location. I differ with that. Okay. I think it's disclose, disclose, disclose. Okay. So I should change that slide so it says disclose and then disclose and then disclose. So disclose, disclose, disclose. I think that is the most important thing that you do, the most important thing that you counsel your client to do. But I'm going to tell you, this is important. This is critical. Disclose, don't diagnose. And that's where we get into trouble. Okay. Question. Thank you so much, Dally. But disclose, don't diagnose. And so remember that AVID form. So let's just take a look at the AVID really quick, because it's just like it's like the poster child of staying out of jail. Okay. So AVID, it's in both of our templates, buyer, offer, and seller listing. So I'm going to pull up my AVID again. There's my AVID, and then here's what I see. So first of all, on the AVID, there's really nothing for you to do on page 1, right? I mean, what are you going to do? You're going to fill it out, make sure the broker's name is accurate, because sometimes the program doesn't populate the way it's supposed to. But look at that, there's nothing to do. Folks, I would take a minute and read it. That's one of the most important things that you can do, is to read the AVID, okay, so that you know what it says and that you're not making statements that are inconsistent with what it says. Then I get into page 2, and this part's not filled out properly, right? What's the weather condition? Well, who cares? Well, at trial, the plaintiff's counsel is going to look up what the weather was, and if you put in here sunny and it was raining cats and dogs, you're going to have a problem. Okay, so you need to put in the weather. You need to put in the first part is the date. The second part is the time, and you need to put in who else was present at your AVID. Okay, but then what I see in here is I see nothing noted, nothing noted, nothing noted. I see stuff like that. And again, if I take you out there, I will guarantee you I will find stuff. Okay, so again, a reasonably competent, diligent visual inspection of the premises. You don't need to unlock doors. You don't need to knock doors down. You don't need to do stuff like that. But I think you need to be doing your AVID with your 5 senses. So, you go to the house, you get this musty smell. You got to figure something might not be right, but you can't really say mold. You can't really say mildew, because you don't know the difference between the two. Frankly, I have a graduate certificate in hazardous materials management. I know the difference. I never tell my client I have it. Okay. So, but boy, what's that smell? That's really weird. Okay. And so, you need to have the place investigated. You need to have the mold level. I had a tenant back out of a deal because they actually had a mold inspection, went down to Home Depot or Lowe's or something and got a home, a kit to measure the moisture levels in the place. And I said, they came back and they said, it's 67%. I said, you're on the water. And they said, yeah, I know, but we're not going to take it because it's 67%. And I said, okay, you live on the water up in Encinitas. Have you done the levels for where you're living up there? And they said, we don't want to know. I said, well, then, okay, bye-bye. I just let them go because there's going to be too much trouble. But you need to write these things in. You need to fill these in. I wouldn't leave anything open. So, for example, if there's no other, put NA, 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 whatever. But, here, what do I get on parking? I get settling cracks noted in driveway. No, please. Remember, disclose, don't diagnose. So don't call it settling. Don't call it minor settling. I had a lawsuit where the agent said that, water stain noted in ceiling of bedroom number 2. I said, you were okay until you got to water. And sure enough, buyer closes the transaction, goes upstairs to find out the source of the water leak by the expert real estate agent who said it was water, and turned out to be paint. The paint cans were up in the attic and they were leaking. And so, listen, don't be making statements like that. So what would you say? So the garage, instead of minor settling crack, listen, all driveways have cracks. All entryways have cracks. All slabs have cracks. Okay. It's when you get into the modifier that says minor, because you're trying to downsell it so that they'll buy the house. Listen, there are some deals, Joe Jelly used to say, there's some transactions you just don't want to close, right? Most of the lawsuits occur after close of escrow, okay? So let's make sure we do it right during the transaction. But, I would put in cracks noted, don't say settling, don't say minor, cracks noted in driveway. It's in all of my AVIDs because all driveways have cracks in them, right? And so, if I have anything else to add, I'll do that. but I certainly, I'm not going to go into a point of saying, I had a manometer reading taken of the driveway. I buy houses with cracked slabs. I bought one in Del Mar down on 519 Stratford Court, and this place had a crack running the length. The tenant pulls the carpet up. I'm the buyer, obviously, and so the seller. This property was not selling, and the tenant pulls the carpeting up and throws it away. And so, I asked, I said, well, why'd you throw the carpet away? And they said, well, because we like the natural feel of concrete. Yeah. And so, well, really what they liked was that crack running down the middle of the floor that, no buyer was going to buy that because it had a crack on the floor. Right. And so, again, the place was built in 1960. Okay. And so I had Pacific Engineering. I don't remember if that's who it was, but anyway, I had an engineering company come out and inspect the property. And they said, that's been there since 1960. So it ain't going anywhere. So good. I had a professional now tell me that, not me, telling a buyer that because I'm the buyer, but the professional telling me that in their expert opinion, it was it was nothing. Okay. You don't want to make those statements. Okay. All right. Anyway, bottom line, I bought the property, sold it for almost twice what I paid for it. Okay. All right. So disclose, don't diagnose. Disclosures, remember that there's a difference between statutory disclosures that have rescission rights and contractual disclosures that have cancellation rights. Okay. I've got graphics going on here. You need to know the difference between the two, and I do that class as well. I think you've been on that one. Everything goes into your transaction management software. That includes, but not limited to, emails, telephone calls, text messages, if you're crazy enough to do them. I had a lawsuit where the agent said, I don't have any text messages, and they said, why not? Well, I changed carriers. So of course, plaintiff's counsel goes out and subpoenas the carrier that he was with before. He's got every message, and when they do that, you don't have a chance to redact anything, and they pay people to go through your text messages. So, I wouldn't be doing that. Okay. So everything, I don't text, but you do whatever you want to do. Well, it's on my client deal. That's the client. I find that I tell the client I don't text. I don't give anybody my cell phone number. So, they're gonna have to send me an email. All right. And they do. They're pretty good about it. Okay. Don't use buyer interest letters. That was the other thing. I pulled that up for you just for here. Buyer interest letters, accompanying offers, legal risks. Again, I'll send you this package if you want it. But I did want to tell you about that. I wouldn't use buyer interest letters, otherwise known as love letters. I would. What about removing contingency at the time of the offer? We've already talked about that. I wouldn't. If the buyer says I want to remove contingencies, I don't care, one or more. Anytime the buyer removes a contingency, you use a CR form. That's a contingency removal form. But at the same time, you want to use that Q&A I showed you. You want SDAR's non-contingent advisory form. You want to make sure you just kill that, right? Okay. Have your client sign off on the Q&As, non-contingent offers, buyer interest letters, those things. SDAR's form, CR has one of their own. So I want to thank you for joining us. And so for most of you, I know that we have a YouTube website. I've been loading everything up to the YouTube website. So get your QR code reader ready. Here it is. I've learned how to do QR codes about 2 months ago. They still work, which is great. Usually it breaks, but we have a QR code. You can also go to @Burke Real Estate Consultants. Oops, I put a period in there. There's no period in there. So @Burke Real Estate Consultants. Yeah, that's it. That's Inc. It says on the end, not .com, but Inc. No period, Inc. Or you can go to BIT. I had to do this because we're going to be doing the RPA class, and I had to put a place for you to get the form that I'm required by DRE regulation to let you know about the class. So that link will take you there at some point. Hannah, thank you so much. Dally, thank you so much, and both of you for your nice comments. Again, here, case is important. And then please remember to like and subscribe. Again, like just makes me feel good. Thank you. Subscribe gives you lets you know whenever there is an update to the forums, or whenever I've loaded another video. Thank you, Dally. Thank you. Whenever I've loaded another video, and I got a bunch of them coming. I know I owe you about 4 of them, so those are the more current versions of those things. Education at SDAR. if you got any idea, if you want me to speak at your brokerage firm, I do them all the time. So just let your broker know, hey, Kevin will come and do the talk. It's usually by Zoom, or Google Meet, or Microsoft Teams. But you know, give me a topic, I can talk about it. Happy to help in any way that I can. The SDR just asked that there at least be a couple people there, that kind of thing. Okay. Weekly emails, you're all used to this. You know, you have, you know, I'll send you my all of the links, so you don't have to worry about. I know that right now nothing is posted on the SDR website for my classes. So none of the webinars are there. We've had a change in staff. But if you're getting my newsletter, then you'll get the link. And so I'm doing these classes anyway, and people are showing up for it. I've got a very good following. So again, if you're not getting the newsletter, send me an email, or if you just send me an email, I'll send you my response will have in my signature line. It'll be a link that you can click on that'll sign you up for the newsletters or for the classes. And again, those are free to you at this point. SDR never figured out how to monetize those, but I'm sure at some point they will. But in the meantime, my videos are free to you as well on the YouTube website. So thank you all for being here. I'm going to get you out of here right on time, and I very much appreciate the value of your time, and I so sincerely thank you for being here. And if there's anything I can do for you, please let me know. This afternoon at 2 o'clock, my talk is going to be for a very large brokerage, so I guess essentially not open to the public, but only open to that brokerage. So again, that could be you next week. You know, whatever you want to do, just let me know. Let SDAR know, copy me on the email, and I'm happy to help you, as you know, in any way that I can. So thank you again, everybody, for being here today. And as I say, from my hometown of Del Mar, I look forward to seeing you around the track. Take care. Bye-bye for now. Bye-bye.